Hi guys, it's Houston immigration attorney Pegah Rahgozar. Welcome back for another episode of Wednesday Wisdom with Pegah. A little bit about the Rahgozar law firm. Our principal office is located in Houston, Texas, but we do take cases from all across the U.S. and outside the U.S. advising on immigration laws. Our office phone number is 832-792-3636, and you can learn more about this topic as well as about other topics and more about me on our website at www.rahgozarlaw.com. So today's topic is about unlawful presence waivers, otherwise known as immigration pardons, as most people refer to. But before I dive in, I'd like to inform you that any information discussed in today's video is for informational purposes only and should not be construed as legal advice. Because every case is different and immigration is a fact-intensive area of the law, it is wise to seek proper legal advice from an experienced immigration attorney before filing any sort of application with immigration. So during Obama's administration back in 2013, the unlawful presence waiver was created, and then later in 2016, that waiver was expanded to include more individuals who could qualify for this waiver. The waiver itself is filed on Form I-601A, which is available on USCIS's website. So foreign nationals who are not eligible to apply for a green card inside the United States must travel abroad to their home country for an immigrant visa. However, in a lot of these cases, these individuals have accrued more than 180 days of unlawful presence in the U.S., and that basically is why they would need a waiver to overcome the unlawful presence bars, which I'll explain shortly. And they need those bars waived before they can get an immigrant visa and return to the U.S. So before this I-601 waiver or this pardon was created, foreign nationals had to first appear for their visa interview. Then they would be told that they had to apply for a waiver. Then they'd apply the waiver outside the U.S. And then once that was approved, they'd come back with their visa. And it really took a very lengthy period of time for the foreign national to be separated from their family. So they basically created the I-601A waiver for very limited purpose for a certain category of individuals who qualify for them. So that way they can spend most of their time in the U.S. while the case is pending and only go outside for the visa interview for itself. So the provisional unlawful presence waiver, or the immigration pardon process, allows individuals who are eligible for certain immigrant visas, such as for immediate relatives or family-sponsored or employment-based immigrant visas, as well as diversity visas, or otherwise known as green card lottery selectees. Those are individuals who only need a waiver of inadmissibility because of the unlawful presence that applies to them in the U.S. before they depart for their visa interview. This new process basically was developed, as I mentioned, to shorten the wait time for U.S. citizens and lawful permanent resident family members to have to be separated from their relatives, while those relatives had to stay outside the U.S. to obtain the immigrant visa. The 3 and the 10-year bar of unlawful presence that I mentioned do not actually kick in until a person actually has accrued 180 days of unlawful presence in the U.S. and then they depart the U.S. So this waiver is essentially asking the U.S. to waive or pardon that bar that they're going to trigger upon leaving for their immigrant visas. And this provisional waiver basically does not change the immigrant visa process, meaning that if your waiver is approved, you still are required to depart the U.S. to process the immigrant visa itself at the U.S. consulate abroad. The approval of the waiver does not make you eligible to actually receive the green card through what's called adjustment of status in the U.S. A side note to consider is if a person is here in the U.S. for 180 days or less unlawfully and then departs, they do not trigger the 3 or the 10-year bar. However, you have to be careful because multiple entries and re-entries, even if less than 180 days, could possibly subject you to the permanent bar, which I won't be addressing in this video, and that's actually a more complicated bar to meet. If you do have any questions about whether you're subject to the 3 or 10-year bar and want to know if you qualify for a waiver or a pardon, then please contact our office at 832-792-3636. Make an appointment and we can discuss your case. So to be eligible for a provisional unlawful presence waiver, otherwise known as an immigration pardon, you have to meet all of the following conditions to qualify. First and foremost, you have to be physically present in the U.S. to file your application and to be fingerprinted for it. So you can't apply from outside the U.S. You have to be inside the U.S. for this particular waiver. The second requirement is that you have to be at least 17 years of age or older. The third requirement is that you must be in the process of obtaining your immigrant visa and have an immigrant case basically pending with the Department of State. And this is usually because you have an approved I-130 petition based on marriage or a family petition, or you have an I-140 petition based on a work petition, or you have an approved I-360 petition, usually for special immigrant juveniles or for VAWA petitions, or you have been selected by the Department of State for a diversity visa program, so basically green card lottery winners. Aside from that, you also have to have paid your immigrant visa processing fees through the National Visa Center for any of the approved petitions that I just mentioned, and you actually have to submit that you submit proof that you paid those visa fees together with your waiver packet. Also, these category of cases include immigrant cases that include spouses and children of those approved principal petitions that I mentioned. The fourth requirement is that you have to demonstrate that the refusal of your admission into the United States will cause extreme hardship to your U.S. citizen or lawful permanent resident spouse or parent. Now, unfortunately, this hardship requirement does not mean hardship to a U.S. citizen or lawful permanent resident children. So those you can only show hardship, extreme hardship, to a U.S. citizen or resident parent or spouse. However, you can use U.S. citizen or resident children to kind of piggyback on the spouse or parent's hardship. So it would be kind of like a secondary hardship, but your qualifying relative are those U.S. citizen or resident parent or spouse. And last but not least, the fifth requirement is that you'd be ineligible to receive an immigrant visa only based on unlawful presence. That means this is the only ground that you have an issue that you need this particular waiver for, because of either overstaying more than 100 days but less than 1 year during one single visit, or 1 year or more during one single visit. So you entered, you overstayed either 180 days to 1 year or over 1 year. And that's it. That's the only ground that you're seeking this waiver for. If it's any other ground, you are not qualified to apply for this particular waiver. You're actually going to have to apply for a different waiver, which I won't be addressing in this video. So one requirement that we just discussed is about the waiver is proving up extreme hardship. The foreign national has to demonstrate extreme hardship to their qualifying relative, as mentioned, is the U.S. citizen or permanent resident spouse or parent, and to prove that they will suffer extreme hardship if they can't be reunited. Some things to consider as extreme hardship. Of course, it's going to be on a case-by-case basis, but these are some of the examples that are laid out in terms of what hardship might be to your U.S. citizen or resident spouse or parent. So health grounds. So basically, if your U.S. citizen or resident parent or spouse is seeking ongoing or specialized treatment that requires them to seek that treatment here, or availability and quality of such treatment in their home country, that could be a factor for extreme hardship. If the anticipated duration of that treatment, whether the condition is chronic or acute, short-term or long-term. So the health reason is really a good ground if you have your qualifying relative that you could show hardship to based on the health ground for them, not for the foreign national. Another thing to consider is financial considerations. So future employment for you or your spouse or your parent, depending on if you're the sole breadwinner or if they are, so things like that. Also loss financial loss basically due to a sale of a home or a business, a decline in your standard of living, the ability to recoup short-term losses, the cost of extraordinary needs such as special education or children or training for children, the cost of caring for family members. So if you have elderly parents that you are taking care of, like I said, those things also can be piggybacked onto the main individual who's going to be the one suffering hardship. In terms of education, that could be one factor also considered is, for instance, the loss of opportunity for higher education or lower quality or limited resources in the home country, the requirement to be educated in a foreign language or culture, the availability of special requirements such as training programs or internships in specific fields. Other aspects of hardship can be personal considerations, such as the close relatives that are in the U.S. versus the relatives back in your home country, separation from any spouse or children, the age of those individuals, whether it's you or your U.S. citizen spouse or resident spouse or parent. You know, if they're older and it's going to be like harder for them to move to a new country and learn all these new things and do all these new things, that could be definitely considered. If the length of residence and ties to the U.S. also get factored in for your own personal considerations. Additional special considerations for extreme hardship can include also culture, language, religious, or ethnic obstacles. For instance, if you or your children don't speak the certain language of the home country, or you have different religious views, those can be an obstacle to show hardship. If you have valid fears of persecution, physical harm, or injury in the home country, or if you think that you'll be socially ostracized or stigmatized, those are things that also can factor in. Also, any other information really that can explain how your personal circumstances qualify you as imposing extreme hardship on your U.S. citizen or lawful permanent resident qualifying family member. And you basically also have to demonstrate that your relationship will suffer more than just a normal or financial inconveniences caused by family separation. What are the steps after getting approved for this waiver? Well, basically, once your waiver is approved, you still have to complete the required steps through the National Visa Center, and that includes your actual visa application itself, and then submitting any additional documents that they require, like the affidavit of support and police clearances and things like that. Once the stage is complete, the consulate will then schedule you for an interview to go back to your home country. Some countries, due to civil strife, might not have a current embassy open, for example, Nicaragua. Then in those certain situations, you may have to designate another country that you can go to go for your visa interview. So that's kind of a side note. Once all that's scheduled, then you have to depart the US to go for your visa interview. And usually it should take a few weeks for the whole process to be complete, between going back home for your interview to actually receiving your immigrant visa and your passport, and then being able to return to the US. Of course, during the interview, it's the last step of the process for this whole unlawful presence and getting your immigrant visa. And that's basically to make sure that you, in fact, are eligible to receive an immigrant visa. So if there's no issues and everything looks good, you'll get your immigrant visa put into your passport, and you're able to return to the US. And once you're back, you'll get your green card in the mail. If you have any questions about whether you're eligible for a unlawful presence waiver or pardon, or if you have questions about whether your case meets extreme hardship, then please contact our office at 832-792-3636. Make an appointment and we can discuss your case. So what are things that make you ineligible for this waiver? Basically, if you don't meet any of the conditions that I mentioned in the last 5-10 minutes, or you're in removal proceedings that have not been administratively closed. So you can't have ongoing deportation proceedings, removal proceedings, and file this petition. Or you have a final order of removal or deportation. If you have a final order of deportation, you could only apply for this waiver after first completing and getting another waiver approved And if you get that waiver approved, which is basically Form I-212, application for permission to reapply for admission in the U.S. after deportation or removal. So if you get that waiver approved, then you're eligible to apply for the unlawful presence waiver, which is the Form I-601A. Another reason that you may be ineligible for this waiver is if your underlying immigrant petition is revoked. So basically your marriage-based petition, family-based petition, employment-based petition, those petitions, if they get revoked, you no longer are eligible for this waiver. Also, if you have failed to establish the hardship, the extreme hardship element, if you can't prove that, you won't qualify for this waiver. Other common reasons that we see where someone is not eligible for this waiver is if they have alien smuggling. So if they help smuggle a family member, even if it's their own children, that makes you ineligible because now you have to, if you qualify, you have to apply for a different waiver, and that is done outside the US. Also, multiple illegal or multiple entries that have already triggered a bar or the permanent bar, or if you are going to be a public charge on the US. Things to consider, of course, before filing the I-601 waiver, the unlawful presence waiver, basically, otherwise known as the immigration pardon. As mentioned, for cases in removal proceedings, if you can get your case administratively closed or terminated before actually filing the waiver, then you may apply. Because if your case is still active with immigration court, then you can't apply for this waiver. Once your case is administratively closed with the court, you can file for this waiver. However, upon approval, you'll have to have your case recalendared in immigration court and will likely have to seek voluntary departure if you qualify. That way you terminate your proceedings and then you depart to go to your visa interview. Because if you don't resolve your immigration court, you're going to end up risking being stuck outside the US and being ineligible for this waiver altogether. When does a person not accrue unlawful presence? So basically, when would this waiver not be needed? And that's going to include the following category of people. So children under the age of 18 years do not accrue unlawful presence. They do start to accrue unlawful presence 6 months after their 18th birthday. If you have an approved DACA, then during those periods that you have an approved DACA, you're not accruing unlawful presence. However, if you have accrued unlawful presence before receiving DACA, during periods of gap between your work authorization periods for DACA, or after, those also are considered unlawful presence. So if you accrue up to 180 days or more, then you're going to, of course, need to apply for the unlawful presence waiver or pardon. If you have a bona fide application for asylum, you don't accrue unlawful presence unless you work without authorization. If you're the beneficiary of a family unity protection program, you don't need this waiver. Also, if you're someone who's eligible for VAWA based on battery or extreme cruelty based on your U.S. citizen or permanent resident spouse or parent, or your U.S. citizen son or daughter, you don't accrue unlawful presence, or if you're a victim of a severe form of human trafficking. That pretty much sums up the eligibility requirements for the unlawful presence waiver. I will say a word of caution though, there are notaries and form fillers out there who, without properly knowing the law or your immigration history and background, advise you that you may qualify for this waiver, file this waiver for you, and then you don't realize it, but then once you go outside the country for your immigrant visa, at that point, the consular officer discovers that you have some other issue like the alien smuggling that I mentioned, multiple reentries, having triggered a different bar like the permanent bar, or a public charge issue, or various other issues such as misrepresentation or fraud that come up that you don't discover until you go to your immigrant visa interview. So please, please, please be sure to seek proper legal advice from an experienced immigration attorney when you file these applications, because it could get you into hot waters pretty much, and then you'll be stuck outside the country, and then you'll have to figure out whether you qualify for another waiver or not. If you guys have any questions related to this topic or any other topics, then please contact our office at 832-792-3636. Make an appointment, and we'll be able to discuss your case further. I do have one question here. Jafir Sheikh has a question about how long to get an I-45 interview in Houston. Currently, the family-based categories for your marriage-based cases are taking about 1.5 to 2 years on average for a interview. And Ms. Wilma Polanco, I don't speak Spanish myself, but I do have staff at the office who do speak Spanish. So we'd be more than happy to accommodate you if you need a Spanish speaker. So that concludes another episode of Wednesday Wisdom with Pegah. Thank you guys, and I will see you next time for another episode of Wednesday Wisdom. Have a good night.